the Ombudsman from the Commission of Administrative Justice, Ms. Charles Dulo, and Mr. Ibrahim Shaw, the Information Commissioner from Sierra Leone. Thank you so much. I was wondering, based on your experience and the existing legislation, what has engagement with the private sector looked like? And also, I'd like to use this opportunity to also ask you about what Ms. Pansy suggested in the previous session, that these access to information laws are in ways outdated because they don't apply in a comprehensive way to private entities that hold most of our data more than governments do. So I'd like to seek your thoughts on that as well. Thank you.
Thank you very much. First of all, I'd like to thank UNESCO and the Philippines government for organizing this process. Our arrivals and settling was seamless, and it worked like with military precision, so thank you very much. To answer your question, we are in a unique position in Kenya because we have our Access to Information Act, which regulates not only government bodies but the private sector. Unfortunately, most of the private sector players were not aware that under Section 2 of the IDUAI Act, we could get this information, and we were to regulate them. So they were not aware, and so through public participation, they have now been made aware, and most of them are happening. But beyond the use of the legislation, we've had two cases. One case which went to court when the Kenya government engaged a private company to collect data and what is now called as the Huduma, the registration. Now, the civil rights Nubian community went to court to challenge the process, and the court held that there is no proper framework to safeguard that data which is being collected by big companies, and because this was going to involve all the citizens being registered, that they needed to have a safeguard to that. The other thing that we have seen coming up from Kenya is basically the Employment Act information that people have been seeking in terms of information. We have also had environmental impact assessment that private companies do undertake, and so some citizens come to ask us for that information, and then we always request the people concerned to give that. One of the challenges that we face is conflict of other laws. Unlike in other countries where the data protection and access to information is resident in one place, for us, access to information is resident at the Commission on Administrative Justice. But there is a Data Protection Act which gives that to the Commissioner of Data Protection. And so there's that conflict, and so sometimes it's very difficult to provide that information. The other thing is that in the private sector, there's lack of internal structures. Unlike the public sector, where the law provides that the public bodies must have access to information officers, in the private sectors, they don't have anybody designated for that. And so when you ask for that information, it becomes very difficult to be able to access it. And then the other thing is also the enforcement gaps, because for the public sector, it's very easy, but for the private sector, it's very difficult to enforce some of the information that we normally ask when people ask for information. I want to finish by highlighting one case. It's not related to the big data, but it's one of the cases which was legislated went all the way to the Supreme Court. It's about the environmental degradation of some slum area in Mombasa, and the people went to court. And in a landmark decision, the informal settlement community were awarded almost $10 million in damages, and the private company that was operating that lead manufacturing product that caused the environment degradation was fined almost about $5 million to make sure that the environment was brought back to book. But then it did not end up there, because even the government agencies which were responsible for licensing, like NEMA, those county governments who gave the license, and the Ministry of National Environment, were found culpable of abdicating their constitutional role. Remember, in Kenya, we have the right to a clean environment at Article 42, and the obligation of the state to ensure that those are provided. So that is a landmark case that I think going forward using it, it will be able to shape up the way we are using and collecting data, and also it also embedded the public participation into environmental, the processes of environmental impact assessment and things like that. So that's what I will say.
That's a hopeful case. Yeah, thank you so much for sharing. It highlights again this idea that access is not enough. Citizens need support to interpret this data and understand it. Yes, please, did you want to respond?
Yes, I just wanted to say something in terms of the engagement with the civil society, because my experience in Kenya has always been like, when they ask for information, they already know the kind of information they are looking for. And a case in point is they requested us to provide, the Ministry of Blue Economy was to provide the amount of money that was spent in counting fish in the ocean. So that information was available to the people, and it was very interesting because the CSO are the ones who brought it to us, and we asked the ministry and they were able to provide. But apart from that, there are other challenges in terms of the environment, which is happening now. There's a lot of booming business in terms of building flats in Nairobi, and most of them are being done by the Chinese companies, and a number of local communities around those areas have gone to court to challenge the idea of using building high rises in those areas, and the infrastructure is not expanding in terms of water, in terms of road. And actually the courts have stopped some of those constructions of very tall high-rise buildings because of that. But the most important one, I also think, also in terms of citizen engagement, the public participation is at another level. This happened during the now famous finance bill. The Kenyan citizens use social media to mobilize people to send information. If there's something that they don't want and they have a position for it, they interpret it. In fact, the finance bill was actually interpreted in terms of, translated into local languages, telling people, breaking down to them what it means and how it's going to affect them. So the same activism by the civil society has made it very possible for us in terms of pushing the government to, or the public service bodies to release the information. The only thing that we need now to move is to ensure that private data, in terms, private corporation holding those data should be able to produce the information. But when they come to us, because we know the law and we look at it, we will be able to give it. The only challenge is that there are certain exceptions under Access to Information Act, which talks of commercial interest, contractual confidentialities, and things like that, that some of these corporations can hide under not to be able to give the information. But I encourage them to have, much as you're going to have non-disclosure agreements, but we also say that you need to have proactive disclosure, and that when you're conceptualizing these projects, you should be able to agree, like if it's public involved, then how much the public is going to pay, how much information you're going to release in terms of the contract, and things like that.
I guess the same principle that applies to governments for maximum disclosure in the interest of the public can apply then to the public, private sector as well. I know we have very little time left, so I'd like to open the floor for questions. Oh, I see one from Ms. Pansy already, and then two more in the back, please.
And also to just ask from information commissioners whether right now when we're looking at the issue of big data, the role of artificial intelligence and capacity gaps or capacity issues within information commissions, where are we, especially information commissions from Africa? Do we have enough talent within the information commissions to navigate the new changes that come with the digital age? Thank you.
Would you like to take this question?
Yes.
Go ahead.
The question about AI, I think that everybody in this room accepts that AI is a great tool, so we need to embrace it. So what we are doing, like from my perspective, is that we train our staff on the issues of artificial intelligence in terms of how to, when they are making a decision on certain information, what to be released and what not to be released. Coming on to the question of balancing the privacy and the right to information. For us, our ATI Act gives us enforcement powers, and so we can make an order. So what we normally do is that we redact the information on terms of sensitive documents, and then when we have given the order, so the request of the information can actually go to High Court and enforce that order. So that is how we balance between confidentiality and privacy vis-a-vis the public interest to know the information. Thank you very much.